Welcome to the Committee on General Laws and Technology. The clerk will please call the roll. Okay.
You have a quorum, Mr. Chairman.
Thank you. Before we start with 7 identical bills that we've heard before, there was HB 2010 from Delegate Les Adams about the Virginia Employment Commission, which was heard, a similar or the same bill was heard in Commerce and Labor before, I believe, or applies to Commerce and Labor. So is there a motion to refer HB 2010 to Commerce and Labor?
Second.
Okay, there's a motion and a second. All in favor of referring to Commerce and Labor will vote aye.
Ayes 13, no zero.
Okay. I'm going to try and be expeditious. There are 7 House bills that are identical to Senate bills that passed, I think all but one unanimously, and I'll call to your attention the 2 that didn't pass unanimously. The first from Delegate Campbell, HB 1542, is identical to Senator Bell's bill that the Senate General Laws and Technology Committee passed 14-0. It has to do with the Landlord and Tenant Act and security deposits. Is there a motion to pass that bill? Okay. It's been moved and seconded that we report 1542. All in favor will vote aye. Okay. The next from Delegate Taylor is identical to another of Senator Bell's bills dealing with confidentiality of archived records of medical and educational nature.
Move to report.
Second.
Okay, it's been moved and seconded that be reported. All in favor will vote aye. Those opposed otherwise. 1844. Okay. The next from Delegate Krizak, HB 1993, is identical to Senate Bill 905 from Senator DeSteff, dealing with training for fire marshals and police powers. There's a motion to report and a second. All in favor will vote aye. Okay. The next, also from Delegate Krizak, we passed one from Senator Reeves that was unanimous, dealing with the Virginia Racing Commission, ratio of live racing days. I don't know if there's, do people remember that bill? Okay, there's a motion to report and a second. All in favor will vote aye. Okay, next we come to Delegate Wilt's bill, similar to Senator Cosgrove's SB 870. The Wilt bill is HB 2128 with the funeral expenses and disposition, refusal to pay or deliver a small asset. There was one dissenting vote in committee here, but it passed to committee 12 yes, 1 no. Is there a motion? Okay, there's a motion and a second. All in favor will vote aye. Okay. Next, we come to Delegate Cordosa's bill, which was identical to Senator Spruill's bill. Delegate Cordosa's bill is HB 2244, dealing with appropriations for African-American cemeteries and graves. Passed the committee and the Senate unanimously. Okay, there's a motion and a second to report HB 2244. Please indicate your preference on the electronic voting board. Okay, another from Delegate Cordoso is identical to SB 1497 from Senator Locke, dealing with the Freedom of Information Act exclusions related to Fort Monroe Authority. Okay.
Second.
And that one passed with one dissenting vote in this committee. All in favor? Oh, I'm sorry, it was an abstention, not a dissenting vote. So please indicate your preference. I heard a motion and a second, so please indicate your preference in the electronic voting board. Okay. Now we come to a similar bill from Delegate Davis, which was dealing with the Data Governance and Analytics Office. The question is we had voted in this committee to remove the sunset on that office, and then in finance, they amended the sunset to have the office expire July 1st, 2024. So it's up to the committee if you'd like to mirror it to the way it passed the Senate or any other action.
Mr. Chairman, I move the sunset.
Okay, so there's a motion and a second to, well, then it would be to pass it as it's,
And refer to finance.
okay, so it would be to pass and refer to finance the way the bill is currently before us, to have that sunset just changed by a year. Okay, so there's a motion and a second,
It is on the request list, yeah.
yeah, for finance, so that will go to finance. It'd be, yeah. So Senator McPike's motion was to pass the bill as written, which would be the way it left the Senate, with the sunset expiring on July 1st, 2024.
Yes.
Okay, so that's a motion. Is there a second?
Second.
Okay, it's been moved and seconded. All in favor will vote aye. Okay. Next, we come to a similar bill from Delegate Coiner, HB 1627, is similar to Senate Bill 1042 from Senator McPike about the Common Interest Community Board. Both bills require the office to make a decision to refer matters or make a determination when a decision conflicts with relevant laws or regulations. However, the House version requires the director, as opposed to the ombudsman, to refer the repeat violation to the board. So really, there's some differences in wording throughout with director and ombudsman. I don't know if Delegate Coiner would like to come forward if she's here. Hi, welcome. Are you aware of the differences between your bill and Senator McPike's bill?
Yes, Mr. Chair. So at the point in time that the senator's bill went through, DPOR had not let everyone know that they were changing the name. So it would be consistent with the title rather than being ombudsman, it would be director. They're just cleaning up the name. So that's the only difference. We didn't have that information when his had gone through.
Okay. So is there a motion then to?
Move to report.
Okay. So all in favor of reporting HB 1627 as before the committee will indicate their preference on the voting board?
You got to, hold on, sir.
Oh, is this also to finance? No, I think based on what the delegate is saying is based on some changes that DPOR in titles, that her version would be fine the way it is and mirror their titles that they have.
Is there a substitute associated, is what you're saying?
Right, but I'm thinking that the director is the title that DPOR said they're using.
Correct.
So,
Yes, Mr. Chair.
so I'm going to entertain the motion, which was to report if I hear a second.
Second.
Okay, so please indicate your preference on the voting board on HB 1627. Okay, thank you, Delegate.
you.
Was that your last bill, or did you have another one?
I believe that's my only bill.
Okay, thank you. Then we come to Delegate Brewer has HB 1688, which was similar to Senator Suderline's 1026. This was the Consumer Data Protection Act. Delegate, what the committee had done to the Senate cognate was referred it to the JCOTS for review in the situations where you have like a 17-year-old in college and wants to have access to a website without checking each one with their parent. Do you have any comments on that action that was taken?
We had just a couple minor changes to the bill. I don't know if it would change the disposition of this committee, but I'll leave it up to the chairman. I'll follow your will on this one.
Okay, so the changes were just minor changes? They don't change the basic process?
Mm-hmm.
Okay.
Mr. Chair, move the PBI gently with letter.
Second.
Okay, so there's a motion and a second to PBI with a letter to JCOTS asking for a review of HB 1688. Please indicate your preference on the electronic voting board.
Ayes 15, no zero.
And now we have Elliott Brewer, you had HB 2385, which was similar to Senator McDougal's bill, dealing with, do you want to explain? This was the TikTok bill?
Right, and we did have a floor substitute as well, so that way we could get the entire House happily on board. So I have a copy
Okay.
of that bill if we would want to go from there.
Okay, so your language is different. Do you want to just outline the changes again?
Yeah, so, Mr. Chair, so basically what we did is we actually added additional foreign entities that was also in some other language with some bills you've probably seen similar with agricultural land and things of that nature. So not just the government, or I guess the People's Republic of China, we also added other foreign entities that are adversarial to the United States into the bill. And that got into a posture that sailed through the House, I believe unanimously.
Mr. Chairman.
Senator Bell,
Mr. Chairman, a question of patron.
you could proceed.
Question, where did you ascertain, where'd you get that list from? Is it State Department or any government source? Where did you get that?
Indeed, it was from the federal definition, and that was put in 3 separate pieces of bills that we have similar that have come out of the House and I believe are also been seen in the Senate.
Okay, any further questions? Got, we can either conform this to Senator McDougal's bill, or we can pass this bill with the change in wording, which would,
Mr. Chairman,
Senator Reeves.
just looking at the delegate, this is Delegate Helmer's, was that his amendment, floor amendment?
Correct.
That tightened it up? Looking at the floor amendment, I think it almost does a little bit better job of encompassing of what we've had discussions about both on the floor and in this committee, and the problem with some lists. So I think it conforms that. I think what we're trying to do, I'm looking at Senator Bell, I think that might be a better version.
Mr. Chairman.
Senator Bell.
Thank you, Mr. Chairman. Yeah, I'm reading the specifically on line 125, that amendment. I agree with the comments for Senator Reeves, because it instead of listing country by country, which can change over time, we're going by the list from the U.S. Secretary of Commerce. So I think this is a better product.
Okay, so I'll just, if we pass this as is, it'll be slightly different than what we sent out of Senator Reeves. So we'll rely on our friends in the House to try
Handle that in conference?
Well, it's either we're either going to pass the way it is or send it in a posture that will go to conference.
I can let.
Second.
Mr. Chair, it'll come to my committee, so I'll take care of it when it gets there.
Okay. So there's a motion and a second to report HB 2385 as presented. Please indicate your preference.
Mr. Chairman.
Yes, Senator McPike.
So I guess even with the amendment, the same question I think applies to our floor debate on this, which is relative to the Chief Information Officer still having the delegated authority through the governor to declare any software, application, or other device to be dangerous and therefore banned from all government devices.
So what I would say is in instances like this, we can always handle some things, I believe, temporarily through executive order. Putting things from the code we can change from time to time, and we're back here every single year. So if there's any changes I think we need to make as time goes on, we can more readily do that.
Follow, Mr. Chairman.
Senator McPike.
The CIO currently has that authority, correct?
I would say that the CIO has partial authority in regard to this, but I would say that, and maybe the House and Senate members would agree, that we ultimately are the ones that make the code. So I think it's important that we make sure that we codify this.
Okay, this is on the list for finance, so if there's a motion to report, it would be to report and refer to finance if we're to use this wording, or any wording, really. Okay. So motion is second to report and refer to finance. All in favor will indicate their preference on the voting board.
Ayes 12, noes 3.
Thank you, Mr. Chair.
Great, thank you. Now, next, we have 17 bills that we have not heard before, and I've got a list of patrons. Delegate Tata, you have HB 1610, is that right?
Yes, sir. Yes. Oh, ready? Thank you, Mr. Chairman and members of the committee. HB 1610 is a bill that will enable localities to use cooperative procurement for agreements for planning, purchasing, and installing playground equipment. The current procurement statute does not allow the design and construction of playgrounds to be performed by the same entity. Installers must be certified to install a specific manufacturer's equipment for familiarity and to support product warranty. The proposed change to include playground installations would enable localities to utilize cooperative procurement agreements for the concept planning and assembly drawings, purchase of materials and equipment, and subsequent installation and assembly of playground equipment. This change would streamline playground procurement and make the entire process much more efficient from concept planning to installation. In 2016, artificial turf and track surfaces were added because it was recognized that this was a non-traditional construction, as only certain companies could install a particular manufacturer's product. Playground equipment would be akin to installing turf and track surfaces, whereby only a small pool of installers are certified to install a particular manufacturer's playground equipment. Allowing this exception, a locality could purchase the equipment and installation together, thereby streamlining the process. And I have Debbie Bryan here from Virginia Beach if you have any questions.
Okay, it seems pretty straightforward. Did Ms. Bryant want to come forward and indicate your support or any?
Move to report.
Okay.
There you go.
Okay.
Thank you.
Thank you. Very persuasive. Okay. And now, are there people? Is there anyone opposed to this legislation?
Mr. Chairman. Mr. Chairman.
Yes.
Mr. Chairman. This here. I have a question.
Senator Rouse.
Thank you, Mr. Chairman. Chairman for the patron.
Yes.
Or Deborah Ryan, if she will. With this piece of legislation, how does this affect procurement from our Minority Business Council and SWAM and small businesses?
Mr. Chair, from my understanding, it does not. I am not a procurement professional, but I don't think it has anything to do with that specific area because there are only a small amount of installers and people who can do this. So I believe the pool would be the same.
Thank you. We had another witness who wanted to give us a counter point. Did you have another view? Please come forward.
Good afternoon, Mr. Chairman and members of the committee. My name is Gwendolyn Davis. I am the Minority and Women Business Enterprise Administrator for Portsmouth Public Schools. I also am the chair of a volunteer group of business owners from Hampton Roads called Equipping Businesses for Success Institute. This bill directly impacts women and minority businesses as well as small businesses. So thank you so much, sir, for asking that question. When you do a project like this, if it is sole source, then you don't have to go to this length to take it out of the list that cannot be sole source. We have 113 businesses listed in EVA who are SWAM certified that can possibly provide this service. Every time I'm in procurement, every time we use a sole source, you can justify why you're going with that particular company. But when you are doing what they're proposing, which is, no disrespect to you, Delegate, you're denying women and minority businesses the opportunity to submit bids for projects like this. So I've seen cooperative procurements go 10, 15 years. That's not allowing everyone who can compete, and they say they can, to submit a bid to localities and the state. So we would respectfully ask that you not support this bill just because it will not allow us to do that. And Virginia is getting a little bit better in terms of the disparity with procurement contracting. It is not there yet. based on all of the disparity studies from 2004, 2010, 2011. We are just doing some good things because of the last two administrations. So thank you very much.
Can I follow up on Senator Rass's question with you? You said it would not allow the minority contracting. Would it not allow it, or would it just not encourage it, or possibly discourage it if people were to engage in one of these contracts without using that list?
Well, when you use cooperative contracts, we just pick it back off of who, say it would be Virginia Beach. And so you're not releasing that bid to EVA for anybody else to apply. And that's not fair. And we have a real problem in the Commonwealth with women and minority businesses being afforded the same opportunities and win state and local procurement contracts. We're just not there yet, and we're hoping that this committee will consider. Thank you.
Okay, you wanted to respond to that point directly, ma'am?
If I could, just
Please.
one point. This is the first time I'm hearing of this at all. And this was certainly not an intent or even ever brought up to the city of Virginia Beach. If it had, we certainly would have addressed it. Again, not being a procurement professional, from my understanding, the co-op procurement part that they want to use has nothing to do with trying to circumvent any process. It just is the part that allows the same vendor to perform design, purchase, and installation. Thank you, sir.
Thank you.
Excuse me, Mr. Chair, may I add to that?
Yes, please.
First of all, I'm the mother of a woman-owned business daughter, so I'm very sensitive to this, but it was also my understanding that this also had to do with warranty. The problems when they were having different groups, they couldn't stand by the work that they had done, and this is specific to playground. I don't know if that helps, but.
Thank you.
Follow up?
Senator McPike.
What was the issue on warranty? I mean, if you have a designer, you have errors in emission process to submit claims. If you have manufacturer issues, you have a manufacturing warranty process related to the equipment itself. If you have an integrated and stamped design that's civilly designed, et cetera, you have means of redressing either the both design errors in emission process or the installation, correct?
So from what my procurement, Mr. Chair, from what my procurement department has told me, their difficulty in doing this is because they, just like, say, installation of a dishwasher, Maytag, and you don't have a Maytag person do it, then the warranty is void. And it was the same issue with the playground equipment. They would purchase the equipment from one source, and then they'd have to put out an RFP for the installation of the equipment. And there was only, it was difficult because there weren't many installers who were able to do that equipment or able to install it so that the warranty would be good.
I guess follow.
Yep, go ahead, Senator.
And so there's one of two things, one of which is it's a design specification issue, which you've nearly designed essentially one manufacturer to provide that service, which there's a competitive question on that. And maybe there's good reasons for it, that there's a performance issue that only one manufacturer makes. Mm-hmm. But I still don't necessarily draw the conclusion that while, yes, there are certified manufacturers, it also goes to what submittal has been accepted by the locality in the procurement process. And so, I mean, ultimately, if there's a general contractor installing it, they can help to determine the warranty connectivity, or they shouldn't be actually acquiring that subcontract because they can't perform to the contract requirements.
Understood, sir. As I said, excuse me, Mr. Chair. This isn't the only exception within this rule. There's two others. One is the artificial turf and track surfaces, and then I believe the others has to do with stormwater. It's in the, there's three. This shall not apply to installation of artificial turf and track surfaces, stream restoration, stormwater management practices. The reason, and my the procurement people within our playground equipment that do that as well. They also do the turf and track services, and they ended up having the same difficulty with that, where they would purchase the materials and then have to put out an RFP, and some of the people who responded to the RFP were not certified to do the track and field, though under the procurement law we would have to choose the lowest bidder, and so it made for a lot of difficulties. So again, I am not a procurement specialist, and if we knew about this issue prior, I would certainly have addressed it. Thank you, sir.
Thank you. Is there a motion on HB 1610?
Move to report.
Second.
Okay, there's a motion, a second to report. Please,
Mr. Chairman.
Senator McPike, you want
Just
to address the motion?
Yeah, just briefly to address the motion. I think that the prior speaker does have some good points. The artificial fields and civil engineering that's currently excluded from this section of the code is very large dollar, and there are some warranty. Playgrounds are typically lower dollar issues, and I think I do have some of the same concern. And in fairness, the patron not knowing it before committee, I get that, but I do have a little concern about it because it is lower dollar, and those are typically smaller businesses that can have point of entry to contracts and opportunities. And I would just have a little bit of concern about it. So appreciate it.
Thank you, Senator. Okay, so we have a motion.
Chairman.
Mr. Chairman,
Yes, Senator Stewart.
could I speak to it?
Please.
Mr. Chairman, I have a contrary view. Sometimes it may be low dollar, but it's also very important because children's safety is incredibly important. And so sometimes you offer those exceptions to the procurement law when there's an important issue where perhaps the safety or the peculiar skill of an individual is more important than the procurement process. And I think that she has given us an example of one of those where the safety of children is more important than the actual procurement process. So I hope that you all will support this bill.
Okay, thank you, Senator. Okay, so we had a motion and a second to report 1610. Let's open the vote and indicate your preference on the electronic voting board.
Ayes 8, noes 6, 1 abstention.
Okay, thank you.
Thank you.
Okay, now, next in the queue is Delegate Dawn Adams. And you had one bill, 1519, on common interest communities.
Yes, sir. I have two bills, but that's one.
Okay, we'll start with whichever one you prefer.
Okay. Well, I'll start with, Mr. Chair, HB 1519, which is common interest communities. And thank you to the members of the committee. This bill adds language to both the Property Owners Association Act and the Virginia Condominium Act to provide that common interest communities or homeowner associations may cancel auto-renewing contracts with a community manager at any time without cause, given at least 60 days' notice. The current law does not allow for contracts with auto-renewal provisions between a common interest community and a common interest manager to be terminated at any time. This is an especially sensitive issue for homeowners associations where newly elected boards may not be familiar with the terms of or have time to cancel an existing management contract with auto-renewal provisions agreed to by the previous boards. The added language ensures that HOAs can avoid a situation in which they are bonded to the additional high-term length of a contract.
Okay, thank you. Are there questions for members of the committee for Delegate Adams? Okay, are there witnesses here from the public who'd like to speak in support of this legislation in the room today?
Mr. Chairman, members of the committee, Nicole Brenner with Reed Smith on behalf of the Virginia Association of Community Managers. Just want to thank the patron and the chief co-patron for working with us on the solution that is represented in the substitute coming over from the House.
Thank you. Is there anyone here who'd like to speak against this legislation? Okay, anyone waiting in Zoom on this? What? Oh, no Zoom. Oh, great.
Recommend reporting.
Okay, so there's a motion and a second to report HB 1519. Please indicate your preference on electronic voting board.
Ayes 15, no 0.
Okay, and Delegate, you have another bill.
Yes, Mr. Chair. This bill has a substitute to clarify reminder notices for requiring and subscription-based services are only required on free trial periods that are longer than 30 days, and I ask the committee to move the substitute.
Okay, so there's a substitute being distributed. There's a motion to adopt it. Is there a second? Okay, motion is second. All in favor of adopting the substitute, indicate by saying aye. Aye. Okay, any opposed? Okay. So this is a different than than Senator Pillion's bill on automatic renewal offers. Why don't you just briefly explain the substitute again to us?
Yes, Mr. Chair. HB 1517 is focused on providing protection measures for consumers who sign up for recurring and subscription-based services and against businesses that advertise products with hidden fees. It requires businesses that utilize recurring billing models or free trial periods longer than 30 days to notify consumers at the end of their free trial is approaching before they have an obligation to pay. Subscription-based goods and services offered on a recurring basis, such as Netflix, have become increasingly popular option for consumers, and frequently consumers enroll in a free trial or promotional offer and then fail to remember to cancel it before they are automatically charged. And so this bill seeks to implement required reminder notices on these free trial periods that last longer than 30 days. And then secondly, the bill seeks to address hidden fees and mandatory charges. Certain industries are well known for advertising one cost and then including mandatory processing or convenience fees at the checkout where that's not previously advertised. And this bill would require that businesses display the total cost of goods or services up front before you reach that checkout.
Okay, it seems pretty straightforward. We've got the operative language on page 8 and 9. Are there questions from members of the committee?
No.
Okay. Are there members of the audience here to speak in support of this legislation? Anyone opposed to the legislation? Okay.
Move to recommend reporting.
Okay, there's a motion and a second to report HB 1517. Please indicate your preference on the voting board.
Ayes 15, no zero.
Thank you.
Thank you, Mr. Chair and Senators.
Thank you. Okay, next in the queue is Delegate Fowler.
All right, Mr. Chairman, I'm here to talk about House Bill 1934. And I think the summary is kind of the best way to start. What this bill does, in addition to submitting an economic impact analysis in accordance with this section, if the agency estimates that the proposed regulation will have an adverse impact on economic growth or increase regulatory costs by more than $500,000 within 5 years of such regulations implementation, the agency shall advise the Joint Commission on Administrative Rules, the House Committee on Appropriations, and Senate Committee on Finance and Appropriations no later than 30 days prior to the next regular session. JCAR shall have reviewed such regulations and issue a statement containing the Commission's findings in accordance with 30-73.3. Now, why is that important? Mr. Chairman, members of the committee, over-regulation can slow economic growth, hurt job prospects for low-income Virginians, and lead to higher consumer prices. Currently, the Commonwealth has over 145,000 regulatory restrictions in its administrative codes, which is above the national average. This legislation would help us to control that. What it does is very simple. It requires the legislature to take a closer look at rules that will cost $500,000 in the first 5 years of implementation. This new process is modeled after a part of what is called the REINS Act, or regulations by the executive in need of scrutiny. I like that. The goal is simply to take a closer look specifically at high-cost rules. Again, red, blue, and purple states have implemented this kind of idea from Florida, Colorado, Maine, and Wisconsin. Currently, the Legislative Rule Committee can make recommendations to the Assembly that rule could be repealed. Again, this is a small change in process, but will lead to more transparency and oversight of regulations, Mr. Chairman. And I have a Mr. Ken Hutchison is here to maybe add to what I just said.
Before we hear from Mr. Hutchinson, I want to ask you a question.
Yes,
is adverse impact defined in the legislation? Because it refers to having an adverse impact. And I'm assuming that there's some positive impacts if there's a regulation, if there was a need for it in the first place. But is there a definition of what an adverse impact is?
Well, I would think an adverse impact would be something that perhaps the General Assembly had not accounted for.
Okay. And you have a $500,000 threshold for review. How did we come up with that? Is that in comparison to the other states, or?
Me and another delegate flipped a coin, and we came up with 500,000. No, I'm just kidding about that, but we just, that was just a number we came up with. So again, if the committee has some better ideas, but obviously we didn't want to make it too low because we would be getting, red flags, all the time. So we wanted to set kind of what we thought would be a reasonable threshold.
Okay.
So, yeah.
The bill, as amended, requires consideration only of the cost of a regulatory action, but no consideration of the benefits, or is that part of the process?
I would say both would be part of the process.
Okay. And you had a witness here, Mr. Hutchinson?
Yes, sir.
Good afternoon, Mr. Chair, members of the committee. Ken Hutchison on behalf of Opportunity Solutions Project, 501c4, promoting free enterprise and free markets. If I could just, before I get into some of the points I was going to make, answer your question. There is no definition to adverse impact. The statute in which Delegate Fowler is amending already references adverse impact, so his bill just captures that language, but to my knowledge, that has not been properly defined. I would also note that in other states, that $500,000 threshold is lower, and it could be higher in one of the 4 states that he referenced in his remarks. But the overall goal of this legislation is really to just make sure that there's a backtrack, that you all have some transparency and notice that when legislation leaves the General Assembly and rulemaking is performed, if it exceeds a $500,000 threshold, it just comes back in the form of a notice to JCAR and the 2 money committees, and then you all have an opportunity prior to the upcoming session to evaluate whether that is a prudent expense on the industries that are regulated in the proposed rule.
Okay, thank you.
Thanks.
Are there, yes, Senator Mason.
Do you have an example for us? You got something that jumps out that would hit the $500,000 threshold?
So not off the top of my head, but clearly I think there's probably some examples out there where regulations over time, I mean, if you think about the number of entities that are regulated on a yearly basis, that's $100,000 a year. So pretty soon you're probably going to see evidence that the rules that are promulgated during the process do exceed $500,000 more. And we just think that transparency would be a valuable tool for you all to have as you all evaluate what has been adopted after the bill or legislation leaves your body.
Mr. Chairman?
Yes, Senator Bell.
Is there any kind of a standard that would define? Is there any kind of standard? They're all bad. I move that the Senate buy new microphones. Is there any kind of standard that would define how this analysis is done so we would know every agency would use the same methodology?
Yes, sir. So again, the legislation is amending an already existing statute that really goes into sort of the robust nature of the evaluation that agencies and the Department of Planning Budget evaluate proposed regulations and determine their impacts on those entities that are going to be regulated, to include adverse impacts, positive impacts to localities, negative impacts to localities, costs to businesses, costs to industries. So it's really just building on the already, I would argue, fairly robust evaluation process that already exists in code today.
Mr. Chairman.
Senator Hashmi.
Just a question for the patron. Are any of the regulations that would be affected, are they regulations that are in place to protect public health or safety or environment? If you could just talk to that.
Well, I think I'm fairly confident that there would be lots of regulations like that. But again, through the legislative oversight, and that would be determined whether such regulations were justifiable or not. And again, I think with respect to public health et cetera, that those types of regulations would probably be justifiable. Absolutely.
Mr. Chair, if I may just address her question.
Yes.
Nothing in this proposed legislation would impact an agency and DPB's ability to promulgate regs. It would just be one additional step of transparency that would be reported back to members of the General Assembly, but no, there would be no roadblocks or barriers or thresholds that would prevent agencies from addressing the concerns raised by the Senator.
Thank you. Okay, are there other questions or motions?
Mr. Chairman.
Senator Mason.
So you got the team reviewing this that hangs a fiscal impact statement on all of us, and you pulled off this one having no fiscal impact?
Mm-hmm. Yep. Well,
Delegate Houdini?
Yep. Houdini. Well, Delegate Fowler would say that I just read the report that they give me, and it said there was no fiscal impact on the agencies to be able to, perform this task. That's the information they were giving me.
It's a miracle.
Of course, yes. Well, it's I guess it's just my day then.
Okay, I believe Senator Stewart had a follow-up question.
I did, Mr. Chairman. Just on these questions that I've been listening to, I want to make sure that I understand the bill, because to me it just appears to be an information bill. The Joint Commission on Rules is already in existence. We used to use it, and I'm not aware that we've used it much lately, but this is just to get their input on these rules and regulations to help us make better decisions. Am I reading the bill correctly?
Senator Stewart, I think that is a fair assessment of the legislation. Yes, sir.
Mr. Chairman, I am reminded from the senator from Accomack who called me ignorant for not voting for his study. So I'd move to report the bill, Mr. Chairman.
Okay, there's a motion and a second to report
Mr. Chairman,
B 1934. Senator Bell.
have we asked for opposition?
No, we have not yet heard from opposition. Are there those opposed to this legislation? Please come forward.
Mr. Chair, members of the committee, as the supporters of this bill already said, this adds a step to what's already a lengthy process that includes public comment and stakeholders. And as it passed the House, this would have the 12 part-time members of the General Assembly on JCAR, 5 from the Senate, 7 from the House. I'll let you guys talk about the ratio there. But it would have them look at any regulation with as little as $100,000 in regulatory costs a year, and any with an adverse impact on economic growth. That term not being defined and being able to be determined by whoever has power in the moment is greatly concerning to us. And we think that there's already access for the public, for the stakeholders through the regulatory process. We should not make it longer, and we should not set up a step at the end of the process that puts this before a legislative body to potentially cause prudent public policy to be subject to becoming a political football. With that, the Virginia League of Conservation Voters urges that you oppose this bill.
Thank you.
Mr. Chairman, members of the committee, Bob Shippey with Sierra Club, and I associate myself with the comments of Mr. Lane.
Thank you.
Mr. Chair, members of the committee, Blair St. Ledger Olson with Climate Cabinet Action, and we also oppose the bill. Thank you.
Okay. Are there any other? Okay, we've heard from the witnesses.
Mr. Chairman?
Yes.
If I may speak to the bill?
Please.
Thank you. We talk a lot about unintended financial consequences of the decisions we make here. We have not long ago decided to include costs to localities when we're looking at our fiscal impacts, because we have passed so many unfunded mandates to the localities. How could it possibly be a negative for us to look at what the regulatory costs might be in making our decisions about prudent use of taxpayer funds? And I think this is an important additional piece of information that we should be looking at and should be responsible for our decisions. And so I hope we will all support the bill.
Thank you. So I heard a motion before we heard the last set of witnesses in favor of reporting HB 1934 Unless there are other comments from members of the panel, we will vote on HB 1934.
Ayes 8, no 7.
Okay, thank you, Delegate.
All right. Thank you, Mr. Chairman, members of the committee.
Thanks. Okay, next in the queue, we had Delegate Head.
Thank you, Mr. Chairman, members of the committee, and I would say to Delegate Mason's early comment about DPB, this, I think I found the fiscal impact statement from the previous one, but we have an amendment coming forward to try to alleviate that. I would ask the chair if you would prefer for me to present the bill, because the line amendments are very, very small, striking 3 words. Would you like to just see the bill first, have an explanation?
What we could take, if the line amendments are, if you're supporting them, we can make the line amendments.
I am supporting those, yes, sir.
Okay.
Mr. Chairman.
Senator Bell.
I don't know if we can grab Delegate Fowler real quick, but having voted on the prevailing side, of which we just passed HB 1934, asked that we bring that back up for voted again. A member can change their vote.
We actually just, I thought we defeated the bill. No, it was passed? Oh, okay. Okay, we're going to have to wait till this bill's concluded, and then we'll entertain that motion, if you can bear with us just a moment. Okay. Delegate, so you had 3 line amendments that have been distributed.
Yes, it simply strikes 3 words on lines 120, so that the sentence on 119 and 120 clarify that an economic impact analysis is not that becomes a term of art, and it just says that it's going to include the economic impact, but not having to go through a full analysis. And with that, it should have removed the fiscal impact, but that, of course, will be up for Senate Finance, I suppose, to determine if that is in fact the case. But
okay, so all in favor of adopting the line amendments as presented will indicate by saying aye. Aye. Any opposed? Okay, so the bill as amended is before us, and you want to explain it further?
All right, thank you. Mr. Chair and members of the committee, this bill promotes transparency and accountability in the regulatory process. Right now, about half of all regulatory actions qualify as exempt, and as a result, they don't appear publicly until they're finalized. Requiring that these exempt actions appear on Town Hall will allow the public to track the process from start to finish, and will give citizens an opportunity to bring any useful information that they have to the agency's attention while it's still formulating the rule, and will make for better informed and more accountable agency decisions. Would add that the posting doesn't impose any new burdens on agencies, because Executive Order 19 already requires executive branch agencies to post exempt actions on the Town Hall. This just simply codifies those actions, and as a result of that, it also does not require any additional cost. And with the verbiage change, we've eliminated there need to be any specific analysis, just simply that they take into consideration the cost-benefit analysis that they're already doing. So that is the bill that is before you.
Okay. Are there any questions for Delegate Head? Okay. Anyone in the audience who'd like to speak for this bill? Anyone in the audience who'd like to speak against the bill? Okay. Are there motions? Okay. The motion is to report and refer to Finance. Has been seconded. Please indicate your preference on the voting board.
Ayes 15, no 0.
Thank you.
Okay, I thank the committee.
Delegate Bell, or Senator Bell. Senator Bell, you had a motion.
Mr. Chairman, I have to withdraw my motion because I wasn't on the prevailing side.
And so, Mr. Chairman, with apologies to the delegate, in order to square up a proxy vote, having voted on the prevailing side by which we approved 1934, I move that we reconsider that vote.
Okay. There's a motion, a second, to reconsider the vote on HB 1934. All in favor will indicate by voting aye. This was to reconsider. Okay.
Ayes 15, no 0.
Unanimous vote there for a minute.
Okay. So
they keep messing with me, man.
HB 1934 is back before us. Is there a motion? Okay, there's a motion, a second, to report HB 1934. Please indicate your preference on the voting board.
Ayes 7, noes 8.
Mr. Chairman, I still thank you and the committee. Thanks, sir.
Thank you. Thank you. Okay. You won one, you lost one. Maybe the order is not good. Okay. Now we have Delegate Walker, I believe, is next. Welcome.
Good afternoon, Mr. Chairman. HB 1569 clarifies that the personnel records excluded from disclosure under the Virginia Freedom of Information Act includes those of personnel employed by Public Safety Office. Under the current law enforcement personnel records are the only ones that maintain this status. This bill merely would apply the same policy protections for all public safety personnel that law enforcement officers already afford. This does not change the FOIA laws as is related to mandatory reporting or release of records of criminal actions conducted by public safety officers. This bill merely seeks to ensure the privacy of all public safety personnel records, not just law enforcement. So we're adding this fire and EMS, allowing them to have the same privileges here. That's the bill in simple terms.
Thank you for the presentation, Delegate. Can I ask you, why would we need to shield EMS workers' records? What's the rationale?
So this bill was brought to me at the request of the Lynchburg Fire Department and the EMS folks there. I'm not sure the exact rationale, but sometimes, people want to know more about people involved, whether it's accidents or EMS, and if there's medical issues and things like that. So since public safety is an umbrella of law enforcement, fire, and EMS, they felt like they need to have that same type of coverage here. And so I'm bringing it at the request of the Chief of Fire Department.
Thank you.
Yes, sir.
Okay. Are there those in the room who'd like to speak in favor of this legislation? Anyone who'd like to speak against this legislation, HB 1569? Okay. There's a motion and a second to report this HB 1569. Unless there's further discussion, we'll proceed to vote.
Ayes 8, noes 7.
Thank you, Mr. Chairman.
Thank you. Okay, Delegate Wampler.
Hey, Mr. Chair, Senators, good to see you. I have House Bill 2419 in front of you. And most of you are familiar with the omnibus bill on charitable gaming that came through last year, sponsored in the Senate by Senator Reeves, and then in the lower chamber, Delegate Krizik. House Bill 2419 provides an exemption in the code for a raffle in Bristol, Virginia. This is hosted by the birthplace of country music. They do a $200,000 raffle in 1 week to sponsor, in part, the Bristol Rhythm and Roots reunion, who some members on the dais have been to. And so we're seeking an exemption in the code for this organization to continue their raffle as they've been holding it for the last 6 years. That's the short of the bill, but happy to answer any questions.
Okay. Are there questions for Delegate Wampler?
Mr. Chairman, I was originally for this bill. I'm kidding. No, Mr. Chairman, this tightens it up, very narrowly allows this organization to do that without opening up the bag of worms that we had before, and I think it's a good bill.
If there's a motion.
Second.
And a second to report HB 2419. Please, was there anyone in the public who wanted to comment? Okay.
I don't know who up here has been.
Senator Locke would like to know who's been to this important festival.
There he is.
You all to go.
Okay. So let's open the vote on HB 2419.
Mamie, you can go with me next year.
Ayes 15, no 0.
Thank you,
Mr. Chairman.
Delegate. Okay, Delegate Maldonado, welcome.
Thank you. Good afternoon, Mr. Chair, members of the committee. Before you, I am here to talk about HB 1702, and I know most people come and say it's a simple bill. Well, I actually mean it. It's a simple bill. It is merely, given the conditions we're experiencing, particularly in our housing crunch and limited inventory, this bill simply asks landlords to move up the date by which they notify tenants that if they renew, what the amount of their new rent will be. We ask for it to be 60 days prior to the end of the lease term. This will not only help give families more time to figure out the proper and most affordable path forward for themselves, but it also helps landlords by ensuring that their units stay occupied and to mitigate any potential evictions that are unwarranted or unintended and unnecessary. That is the short of the bill. I'm happy to answer any questions.
Are there questions for Delegate Maldonado? Yes, Senator Donovan.
I'm just curious. We had a bill like this. There was a similar bill that was specifically about notifying of increases, or was it limiting the amount that it could be increased?
That was Senator McPike's bill, which is not exactly the same. Senator, do you want to explain?
Yeah, it is a different code section, and I believe the delegate has another bill that we'll probably see next week, since it's not on this week's docket.
Mr. Chair, I would say that that bill that the delegate is, the senator is referring to is my companion bill, HB 2022, that died in committee, which Senator McPike had a companion to. That bill helped to address an issue in our affordable housing, mostly relationships where landlords are permitted to increase the rent during the lease term. I was putting forward a bill to limit that. This is a different bill.
Okay, so this bill really just says that you're getting a written notice of the increase, 60 days, is that correct?
Yes, Mr. Chair.
Okay.
We're not asking. What it does not do is it doesn't tell landlords how much they can increase. What they're simply saying is honoring what they already have to do, but moving it up to give families more time to figure out what their best path forward is.
Okay, are there members of the public with a position on this particular bill who would like to come to the microphone? Please come forward. Welcome.
Thank you, Mr. Chairman, members of the committee. Christy Merrill with the Virginia Poverty Law Center. We thank the delegate for bringing this bill and strongly support it. We do see, and in fact, in my office, we're just reviewing a lease from a tenant today, which contained the very thing that this bill is designed to address. In a multi-page, 10, 12-page lease, at some point it said, oh, if you allow this lease to automatically renew, your rent will go up by 3%. That is valid. That would, again, Senator McPike's bill would address that issue. This does not, in terms of whether or not that 3% increase is honored. But what won't happen unless this bill passes is that tenant won't get a reminder 60 days out, oh, your rent is going up. And without that reminder, most tenants who may not have remembered or even seen that to begin with will not pay the full amount of the new rent, will get a pay or quit notice, and that could in fact lead to an eviction. So we strongly support this bill as a good consumer protection, tenant protection notification bill, and hope that you will report it.
Thank you.
Mr. Chair, Brian Koziel with the Virginia Housing Alliance. We appreciate the delegate for bringing this bill and support it.
Thank you.
Good afternoon, Mr. Chair. Erin Corman with the Realtors. We also support the bill.
Thank you.
Good afternoon. Ms. Mahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We also support the bill.
Wow, you've got agreement from
Mr. Chairman.
From a number of stakeholders. Yes.
Just one question.
Senator Donovan.
What's the penalty for failure to comply?
Thank you for the question, Mr. Chair. I would say to the senator that whatever is available in the contract at law is what the remedy would be. Most times the parties work it out, but if there is not a specific redress, then it would be whatever is available in contract law.
Does council want to address that? What would happen if someone who violated this?
Thank you, Mr. Chairman. My understanding does, I think, align with what Delegate Maldonado just said, that it would come down to whatever else was in the Virginia Residential Landlord and Tenant Act or in the contract as far as what the enforcement would be.
Thank you. Okay, so we have a motion. Is there a second to report? Okay, motion and a second to report HB 1702. All in favor, please vote aye.
Ayes 14, noes 1.
Okay, thank you. And did you have one more, or was it your complete?
That is it. Thank you
Okay,
very
great.
much.
So next in the queue, we had Delegate Rome. Welcome.
Thank you, Mr. Chairman. And we were just joined briefly by the Osborne Park High School robotics team sitting behind us. So on behalf of the Prince William delegation of Senator Stewart, Senator McPike, Senator Barker, and Senator Bell, plus myself and Delegate Maldonado, I am grateful that they wanted to watch the legislative process. So, Mr. Chairman, and to the members of the committee here, HB 2006, the way that we've amended it is this is now a local option bill, and this codifies existing practice for a number of localities where they can have basically they can charge for FOIA fees online or through the phone, as opposed to just making people go all the way over to their local government center in order to pay for a FOIA filing fee. This is an issue in particular that we've had in Prince William County, where we've had constituents of mine in Haymarket, for example, and some of us, Senator Stewart and Senator Bell's constituents, who are driving half an hour to get to the McCourt building to simply file this. And this is our very kind, gentle way of telling Prince William that, yes, you do in fact have authority to be able to take this over the phone or via email or via the internet.
Okay, so you can make a FOIA payment over the phone or the internet.
Yes.
Basically, they can accept
Yes,
that.
it's codifying existing practice, but because we're a Dillon Rule state, we kind of are supposed to be codifying that to begin with.
Okay, are there any questions for Delegate Rome from members of the committee? Are there members of the audience who'd like to weigh in on this bill?
Thank you, Mr. Chairman, members of the committee. Megan Ryan with the Coalition for Open Government. We do support the bill. However, we also think that this should be mandatory and not local option, that it's mandatory if they're already using these technologies. It is 2022, and they should be using them. Well, it was 2022 when I woke up this morning, I'm telling you. But yeah, so we're in the 2020s. How about that? And electronic payments are ubiquitous. Younger people are often not carrying cash or don't even have checks. And so we feel like if this is being used for any other services that the public body, whether that's local or state, that they should also be using it to be accepting FOIA payments. So we thank the delegate for bringing this bill.
Thank you. Welcome.
Thank you, Mr. Chairman. Catherine Ford with the Virginia Press Association. We want to thank the delegate for bringing this bill. We support any efforts to make the FOIA process easier. So thank you.
Okay, great. Is there a motion or questions? Okay, are there any opposed?
Hope not at this point.
Great, okay. So there's a motion and a second, but on the floor, but there might be questions from members of the panel or comments?
Just entertaining the permanent mandatory.
Oh, you'd like to amend it to make it mandatory?
Mr. Chair, so in order for us to get it out of the House, we were required to have to make it may instead of shall. I am absolutely in agreement with the senator on this. I would love to make this mandatory, and at the same time, counting to 51 in the House by doing that is very hard.
Okay. Okay, thank you. So we have a motion and a second to report House Bill 2006. All in favor, please vote aye.
Ayes 15, no 0.
Okay, now we have House Bill 2007,
Thank you.
which is also a FOIA bill, I guess.
Yes, thank you, Mr. Chairman. Mr. Chairman, to the members of the committee here. So HB 2007, this is about localities having to post what their FOIA filing fee processes and just like payment information, all the other sort of stuff that's associated with the fee online. And this was actually a recommendation of the FOIA Advisory Council in 2021 with our esteemed Senator Locke chairing that council. So This was part of a larger recommendation. I tried to get the full recommendation done last year. The Gen Laws Subcommittee did not take favorably upon two of the parts, but we got peace in the valley on this part. So basically, this will make sure that we've got the public aware of what the process is before they even begin to engage in the first place. And this will also make sure that the locality in this case can simply point to what they already have online so that the public, again, knows what they're getting themselves into before they actually make the request.
Okay, thank you. Are there those in the audience who'd like to express their views on this particular bill?
Hello again. Catherine Ford on behalf of the Press Association and Virginia Coalition for Open Government. We support the bill.
Thank you. Okay, are there any questions from members of the committee or motions?
Second.
Okay, there's a motion and a second. I believe I invited people forward who had other views. I don't see anyone. Okay, so there's a motion and a second to report House Bill 2007. All in favor, please indicate aye on the voting board.
Ayes 15, no 0.
Thank you, Mr. Chairman.
Thank you. Okay, next we have Delegate von Valkenburg.
Hello, Mr. Chairman, members of the committee. I have two. Do you?
Whichever one you prefer.
We'll do 1725 first. 1725 is a different version of a bill we saw last year about fraudulent claims for emotional support animals. This committee sent it to the Housing Commission last year, and we worked through the summer to get this bill in a different posture. And so what you're looking at now is going after the kind of online service providers who take minimal, if not negligible, steps to establish when an emotional support animal is genuinely needed. After we had our committee meeting, I literally had dozens of people texting me the TikTok videos of people showing someone how to get an emotional support animal fraudulently. And so the bill in front of you today makes it an offense under the Virginia Consumer Protection Act to provide supporting documentation that verifies the need for an emotional support animal if the provider knowingly provides fraudulent documentation. So this is just going after the providers. And so suppose the landlord or an apartment manager finds specific organizations or companies that are doing that. They can go to the OAG, they can go to a Commonwealth attorney who can file a Consumer Protection Act, use the Consumer Protection Act, which would be a civil penalty of up to $2,500 per violation for the punishment. And so this proposal is trying to hold those fraudulent providers accountable while not inhibiting a tenant's ability to receive an emotional support animal if they need one. Since it's in the fair housing section of the code, there is a self-destruct clause in case HUD comes back and says it's not kosher. This bill got out of the Housing Commission on a 19-1 vote, and I hope you all vote favorably on the bill.
Thank you. Okay, are there questions for Delegate von Valkenburg on this bill? Yes, Senator Stewart.
Delegate, can you tell me where in the bill, I couldn't find it, it just targets the person who is manufacturing these documents and not the actual tenant?
Yeah, lines 45, Mr. Chair, lines 45 and 46. No person listed in these clauses shall provide fraudulent supporting documentation to evince the existence of a disability or disability-related need for a person requesting a reasonable accommodation pursuant to this section.
Mr. Chairman.
Senator Stewart.
I saw that, but that could include the tenant that is passing a document to the landlord. And oftentimes, no offense intended, some of these folks aren't the most sophisticated and they may not understand the consequences of that document. I understood you to say it only goes after the manufacturer of the document and not the actual tenant. The language you just read goes after the tenant as well. And under the Virginia Consumer Protection Act, they're treble damages. So it's pretty significant.
Sure. So, Mr. Chair, if you want to wordsmith this, I'm willing to wordsmith it, but I would suggest that where it says provide supporting evidence to a person requesting it is saying that it's it's going from the person, right? Someone requests it, right, and it's the person who's providing to the requester, right, is hitting that provider language. So if that makes sense.
Makes sense to me. Senator Stewart, does that satisfy you, or did you want to amend this in some way?
Mr. Chairman, Well, I don't know what I mean, I think I understand what Delegate's trying to get, but I don't think I can do it right now. What I'm telling you is this bill actually would impact the tenant who gives a document to a landlord and says, I have a disability and I need a service animal. And I don't think anybody here wants to do that. But maybe I'm wrong.
Well, actually, it says no person listed in clauses little I through, I guess, little 4.
So yeah, Mr. Chair, it's referring to the section above it, and it's talking about a mental health service provider, an individual or entity with a valid, unrestricted state license, certification, or registration to serve persons with disabilities, a person from a peer support or similar group that does not charge service, a caregiver, reliable third party, or government entity. So it is referring to those groups in Section E. So it's not referring to the tenant. It's referring to those 4 groups that would interact with the person. So that, Mr. Chair, that would be lines 38 through 44.
Okay. Are there any other questions for Delegate von Valkenburg, or are there witnesses here who'd like to express their position on this particular bill? Please come forward.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We strongly support the bill. This is something that we commonly see in our units, and it wouldn't affect those who really do need that emotional support, animal accommodation. So we ask that you support the bill. Thank you.
Thank you. Hi, welcome.
Mr. Chair, Erin Corman with the Realtors again, and we also support the bill.
Thank you.
Hi, Mr. Chairman. Troy Garrett with the Virginia Association of Housing and Community Development Officials, and we also support the bill.
Thank you. Okay, unless there are further questions, we can open the floor to motions.
Move to report.
There's a motion to report. Is there a second?
Second.
Motion and a second. All in favor of reporting HB 1725, please indicate your preference on the voting board.
Ayes 14, no 0, 1 abstention.
Okay, so that bill is reported, and then we have HB 1735.
Yeah, thank you, Mr. Chair. Mr. Chair, members of the committee, there is a line amendment that the OAG's office suggested to make sure that lines 71 and 72 of this bill are lined up with 107, and it's just a technical amendment, so I didn't know if you wanted to move that before or after I explained the bill.
There's a motion and a second to adopt the amendment that inserts some language saying, including any summons for unlawful detainer on line 107. All in favor will say aye.
Aye.
Okay. And then we will hear about the bill.
Okay, thank you, Mr. Chair. Mr. Chair, members of the body, 1735 provides some technical amendments to the Statement of Tenant Rights and Responsibilities disclosure requirements. And the reason for these technical amendments is what we were having is confusion in the courts about how to interpret this document when a tenant might not end up signing the tenant rights for whatever reason. And so the goal with this bill is to make sure both the tenant and the housing provider are on the same page about their housing obligations, as well as to make sure that landlords are recording when and how often this statement is being provided to the tenant. And so what it does is it requires housing providers and landlords to record the dates on which they provided this form to the tenant and make record if the tenant doesn't sign the rights and responsibilities acknowledgement form for whatever reason that may be. So currently, they sign the form at the end of the statement acknowledging that the tenant has received the statement, but there's no requirement to make a record if they fail to, if it doesn't get signed. And so this bill eliminates any confusion around that. It also eliminates confusion on the part of the landlord about when to provide the disclosure to the tenant, particularly when it involves lease renewal or updates to the Statement of Tenant Rights. And it does this by adding a section to the disclosure that instructs the tenant to check the DHCD website periodically for updates to the disclosure. And like I said, this was kind of brought forth because what was happening is when someone didn't sign, there was confusion in the courts. If either the tenant or the landlord brought action into the courts, there was confusion over how the court should handle this when it wasn't signed. And so this just kind of creates a process for that.
Okay. Are there questions for Delegate von Valkenburg? Okay. Are there those in the room who'd like to express their preference on this bill?
Mr. Chairman, Troy Garrett again with the Virginia Association of Housing and Community Development Officials. I'd like to thank the delegate for bringing this forward, and we support this bill.
Thank you.
Mr. Chairman, members of the committee, Bisma Ahmed, Apartment and Office Building Association, Virginia Apartment Management Association, we support the bill.
Thank you.
Mr. Chairman, Erin Corman with the Realtors. Want to thank the delegate for bringing this bill. This is definitely an issue our members have been dealing with over the past year, and we support the bill.
Thank you. Okay, there's a motion, a second, to report HB 1735 as amended. All in favor will indicate their preference. Okay, before you leave, delegate, I did not heed the letter from the Finance Committee about your previous bill, HB 1725, that needs to go to Finance. So technically, we need to just reconsider that and report and refer.
Move to reconsider the vote, which we reported, House Bill 1725.
So all in favor of reconsidering HB 1725 will vote aye. Okay, now we'll...
Move to report and refer to Finance.
Okay. We will consider that motion to report and refer to Finance, HB 1725. Please indicate your preference.
Ayes 14, no 0, 1 abstention.
Okay.
Thank you, Mr. Chair, members of the committee.
Thank you. Okay, next we have Delegate Bulova.
Good afternoon, Mr. Chairman.
Good afternoon.
All right, thank you, Mr. Chair. Members of the committee, House Bill 1633 addresses an issue dealing with access to the Virginia Contractor Transaction Recovery Fund. And I think for those of you who are familiar with the fund, you know that it helps customers who have incurred losses through improper or dishonest conduct by a licensed residential contractor. So that's a fund that's not supported by tax dollars, rather it's supported by a special assessment that is applied to all licensed contractors. Under the current code, to be eligible for relief under the fund, a person has to have been awarded judgment by a court of competent jurisdiction against a contractor. The issue that this bill addresses is that actually a growing number of residential contractors are using mandatory arbitration clauses in their contracts. And so rather than going to court, the case has to go to an arbitrator. And since judgment from an arbitrator is different than judgment from a court, that can actually interfere with a person's ability to access that fund. Mandatory arbitration is nothing new, but it actually is something relatively new in terms of becoming more common in residential contracting. And so, unfortunately, most people, when they enter into mandatory arbitration, don't realize that that could inadvertently block them from accessing the recovery fund. What this bill does is just solves that problem by allowing a person to access that recovery fund if they have a positive judgment from a court or if they've got a positive judgment from an arbitrator. With that, Mr. Chairman, happy to take any questions. I am happy to note that the governor and DPOR have indicated their support for the bill. And again, happy to take any questions.
Are there questions for Delegate Bulova? Okay. Are there members of the audience who'd like to express their support or opposition to the bill? Okay. We're open to motions on HB 1633. Second. Motion and a second to report. That one was not on the list for... Not on the list. Okay, great. So please indicate your preference on the voting board.
Ayes 14, no 0, 1 abstention.
Thank you very much, Mr. Chair, members of the committee.
Thank you. Okay, next on the list, I've got Delegate Weber. Is this 2347?
Yes, sir. It is a bill that I've carried before, and you have seen before, and I carried it last year. And what the bill does is it sets up the regulatory budget program for us to be able to continue to take a look at and expands the pilot program that we passed, that we utilized with the Department of Occupational Licensing under the Northam administration to the full executive branch. The bill, as it's currently written, we do have a substitute prepared if we need to, as well, depending on the committee's favor. This one particularly lets the executive branch or the different avenues of the executive branch sort of set their own guidelines or their own goals when it comes to regulatory function or the removal and streamlining of our regulatory atmosphere.
Okay. Are there significant differences from
There
last
are
year's?
significant. Well, the substitute the alternate substitute is basically sets up more in line with the executive order. The bill that's in front of you does not. It's similar, but not. It doesn't set the substitute sets specific goals of 30% and ends in 2027. Whereas the original 2347, the different executive branches get to determine what their own.
Okay, and you'd like us to
reductions
adopt
are.
the substitute, right?
It's the will of the body.
No, okay.
So, again, that's what the bill does. And, as somebody who is in constant look of our regulatory process, we're just going to continue to try and find means in which we as legislators can get consistent feedback in order to say, hey, this is something that we do or do not want. And as we pass legislation and continue to, as we've passed legislation in the past, we'll say deep or shall promulgate regulations. And over time and changes in technology, some of those regulations may not be necessary, but they're still around, or they have, duplicate paperwork, et cetera. So this is just one means that I brought forward in order to continue to try and look at that.
Thank you for the explanation. Are there questions for the delegate? Are there those in the audience who'd like to express their support or opposition for HB 2347?
Chris Lane, Virginia League of Conservation Voters. While I have not had a chance to review the substitute, I believe the comments I'm about to make are going to be relevant to both the introduced and the substitute. So we know that regulations are intentionally introduced to accomplish a specific aim, whether it's public health, safety, or environmental protection. If I promulgate, or if a regulation is promulgated that says you have to bolt your dresser to the wall to keep it from falling on a child, that's not someone going to try and say, I want one more regulation. That's someone saying they don't want the dresser to fall on the kid. And none of that consideration of merit of why the regulation is put in place is considered by the Department of Planning and Budget when it looks at other agencies and says, here's where we want to see your regulatory targets be. I agree with the delegate that evaluating regulatory performance by periodically assessing the sufficiency of regulations and their ability to accomplish those goals efficiently and effectively, that makes a lot of sense. But empowering a budgetary agency to set numerical limits or reduction targets for other agencies based on a number of regulations rather than whether or not those regs are effective, that doesn't make sense. And the Virginia League of Conservation Voters does not support this bill, and we urge you to vote no.
Thank you.
Mr. Chairman.
Senator Hashmi.
Just a question for the speaker.
Chris.
Based on what you just said, then, would you say that we already have a process by which our state agencies routinely review regulations and have the opportunity to modify or to eliminate unnecessary regulations?
That's my understanding, and that's how we'd like that process to move. Forward with the people who regulate health, looking at health and their secretary and their administrative structure, evaluating whether or not those regs are needed, rather than setting this sort of system-wide approach that doesn't look at why the regs are there in the first place.
Thank you. Yes.
Mr. Chair, members of the committee, I echo Chris's comments. I'll also say that while, Blair Climate Cabinet Action, I'm sympathetic to trying to avoid regulatory burden. Those regulations were placed to protect the environment for a reason, and this would jeopardize many of the environmental regulations that we currently have before us. Thank you.
Thank you. Okay. You had a view as well? Please come forward.
Mr. Chairman, members of the committee, Emily Francis with the Southern Environmental Law Center. We respectfully suggest that the legislation is not necessary, as evidenced by the Governor's Executive Order 19, the Office of Regulatory Management, and the administration's current goal to reduce 25% of regulatory requirements across all agencies. So we thank you for your consideration.
Thank you. Okay, did you have any
Sure.
concluding comments?
Well, if I may, just real quick, the Office of Budgetary Management and the reduction of 25% sounds awfully familiar, like the pilot program that we passed for DPOR under the Northam administration with Secretary Lane. The way that this particular bill works is that when it comes to a regulation, so say an environmental regulation that that particular executive branch or that part of the executive branch deems they would like to get removed, that requires legislation, and so therefore we would be bringing that forward. A regulatory requirement would be something like a form on a sheet or something other that they themselves can change. They can, and also when it comes to certain regulations, there's still a process for that particular body to go through public process in order to get that regulation removed. The bill, if you don't adopt the substitute, allows those branches to set their own requirements, not just 25% or 30%. So that's basically what the bill does. And again, that's what we're constantly looking, because I mean every year many of us in the General Assembly always bring forward legislation to try and remove something and trying to get a consistent look at it, particularly with the success that 883 had with the Department of Occupational Licensing. I think trying to expand that is a good thing.
Thank you. Okay, is there a motion or questions from the committee? Okay, there's a motion to report. Is there a second to that motion? Okay, so the motion is to report and refer to finance. Please indicate.
Speaking of the motion.
Senator McPike.
Just to not belabor, appreciate the delegates' interest in working through different stuff. And I think this committee has seen a couple things, actually sponsored by one of our committee members, that did some deregulatory efforts on dams that would bring cholera, and dams would be breaking and walls would collapse, and some other concerns. And I think we do have a deliberate process for a reason, and I would certainly be opposing the motion with certainly due regard to the patrons.
Okay. Then we will vote. There was a motion to report and refer to finance. Please indicate your preference on the voting board.
Ayes 6, noes 9.
Thank you, Delegate.
Chairman. Mr. Chairman.
Senator Bell.
First, I want to compliment the delegate on his very snazzy outfit today. Yes, it seems to be a trend here. I would ask, I don't know if we can do this without making another motion of PBI with a letter, but we've had these we've talked about this every year, and I almost feel like we would be better. I know we had the pilot program, but I feel like we'd be better if we had some sort of a study to come back to us. We're going to keep getting these every year. And I feel like just saying cut regulations by 30%, again, if it is a safety issue, that may not be the right way to do it by just putting an arbitrary number. But I think it would be better if we had some sort of a roadmap of how to best do this without doing harm. And if you would accept a motion to do that, I would move to PBI with a letter.
Well,
I would think DPOR might be the best one.
Mr. Chairman?
First for Senator Bell, we'd have to reconsider the previous motion if we did that, but we'd also have to talk about who you'd want to study this. Senator McPike, you had a comment?
Yeah, just to the senator's thought or potential future motion. I think what we've heard and understand of the regulatory process is each of the agencies already have the ability to review regulations through the regulatory process and to bring those forwards. And so it's my understanding that through the executive order that they're already undertaking some of that, and through that process have the appropriate level of public input to it. And so I think the effect of the existing authority takes the same effect of the senator's idea. If that makes sense.
Mr. Chairman?
Senator Bell.
I would respectfully disagree because that hasn't scratched the itch for us. And I think we'll be back here again. So,
Second.
So I would, let's see, I did vote on the prevailing side. Having voted on the prevailing side, I move we reconsider.
Okay, wait. The motion failed, but you were on the prevailing side, so you want to reconsider that so you can make another motion?
Just doing it twice for you.
Well, Mr. Chairman, I guess the parliamentary inquiry here, since it failed, can I just make another motion?
Yes. You have to reconsider.
Yeah, so I move to PBI with a letter from the chair.
We're still on the same bill.
Well, I don't know if do we need to reconsider it, or we can just take another motion? Okay, so your motion is in order to PBI the bill with a letter to DPOR is what you would like?
Mr. Chairman, I'm open to where the best place is. I don't know if council
Well,
has
there
any
is an
offer.
Office of Regulatory Management that's already doing something similar, but I don't know if they're the ones to study it, who you want to study it.
We could send it to Senator Peterson, who has a lot of knowledge. Mr. Chairman, I would defer on that. I don't know who's the best one, regulatory board.
You could send it to the Department of Planning and Budget, but I'm not saying I'm for it. I'm just saying that's where you could send it.
Might be a good suggestion.
So moved.
Okay, so the motion I'm hearing is to PBI HB 2347 with a letter to the Department of Planning and Budget asking them to review it and report back to this committee and our counterpart in the House.
Yeah, agreeing on that one.
Okay.
I appreciate it, sir.
Okay, all in favor of PBIing with that letter will indicate by voting yes.
Ayes 11, noes 4.
Okay, progress for you.
A little bit.
Okay.
Appreciate it, thank you.
Okay. Now, Delegate Wilt, thank you for being patient. You have, is it just HB 2133, or is there another bill as well?
No, you took my other bill up earlier,
Okay.
Mr. Chairman. So yes, before you, Mr. Chair and committee members, is House Bill 2133. The bill would clarify that the State Fire Marshal's Office, a component of the Virginia Department of Fire Programs, is the authority having jurisdiction in and on state-owned property, including institutions of higher education, to ensure all state buildings are held to the highest standards of safety. The bill would clarify that the State Fire Marshal's Office has the power to enforce the code on all state property. And that's the bill.
Sorry to keep you waiting. Was there any opposition, or can you tell us where the bill came from? Was there any dispute on this?
No, Mr. Chairman, but I would, if the committee's indulgence, I do have an expert here.
Okay, we'll hear from your witness.
Mr. Chair, Spencer Willett, Department of Fire Programs, represent the State Fire Marshal's Office as well. So this legislation stems from, currently the code says that the State Fire Marshal is the authority that holds the liability for all state-owned buildings, including the one we're in right now, and properties across the state. Some state entities and institutions of higher education have their own safety divisions that may have people that are qualified to inspect, but the code does not make them hold the liability for that. And some of those safety divisions sometimes make the claim that they don't need to be inspected by the State Fire Marshal. We encourage them to have those divisions. State Fire Marshal's Office only has 30 fire marshals for the whole state. But at the end of the day, when there's a violation or there's a need for an inspection, it should ultimately be the State Fire Marshal's authority, because if, God forbid, something catch on fire in a dorm building, then you're going to be asking the State Fire Marshal what happened, not that entity itself.
Okay, thank you. Thank you for the explanation.
I do have a
Senator
question.
McPike.
Thank you. I guess question for fire programs.
Yes, sir.
And so How many fire marshals do you have to go inspect different state? Because this is a local responsibility. Are you going to be coming back for additional fire marshal positions in the budget?
No, Mr. Chair.
I'm just getting it on record right now because I'm waiting until the budget amendment next year.
Mr. Chair, so localities with their own fire official, they can inspect these facilities for the state fire marshal. This does not change that. This just makes us the ultimate authority. Whereas if they inspect those facilities and there's a violation, we're not trying to take away. We do not want to be inspecting all the facilities for localities that have their own building officials.
Okay, but follow up, Mr. Chairman.
Senator McPike.
If you're designating authority having jurisdiction, no other authority can have authority having jurisdiction. I think anybody in law enforcement and anybody else, once you've designated that, I'm not sure local can come in and take any. You've transferred all the Fire Protection Act over here, so. I don't know. I mean, it's very much similar to federal government has jurisdiction, and they inspect all their buildings.
Mr. Chair.
Local government does not.
Yeah, let's hear from the witness.
Senator, so the state is ultimately responsible for these any state properties or buildings. So our 30 fire marshals that we have currently are inspecting those facilities and making those inspections every year. So this bill doesn't change that. This just makes them the authority for those entities that have their own safety divisions. This actually doesn't have anything to do with the local fire marshals. We typically don't inspect with them, if that makes sense.
Okay. Are there others in the audience who'd like to weigh in on this particular bill? Okay. Are there members of the committee with questions or motions? Okay. There's a motion and a second to report HB 2133. All in favor, please indicate your preference on the voting board. Same as those otherwise.
Ayes 15, no zero.
Okay. Next,
thank you, Mr. Chairman, committee members.
Thank you. Okay, now we have Delegate Davis.
Hold on. Okay. Mr. Chairman, we have House Bill 1490. House Bill 1490, there's actually a substitute, I believe, in front of you.
Okay, a substitute's being distributed, and there's a motion to accept the substitute and a second. All in favor of entertaining the substitute will say aye. Aye. Any opposed? Okay. Do you want to explain that?
Sure. Mr. Chairman, the substitute does exactly what the initial bill did. It just kind of adds a little bit of clarifying language down in Section G. It said the same thing, but one of the industry partners just asked for us to rephrase it, so we rephrased it. What this bill essentially does, though, is when you have an indefinite delivery or indefinite quantity contract, our small minority businesses today have to bond the whole thing, and as we know, our small minority contractors only have so much bonding capacity. And in many cases, these contracts are awarded up to, let's say, $10 million, and there's no guarantee that they get any of it, much less when they would get it. So what this bill does is it says that you only have to bond the contract for what you are given when you are given it. So if you get a $10 million contract and a month later you're awarded a task that's $1 million, you have to bond that $1 million. When that contract is over, that bond ceases, and the next time you're given a task off that contract, you bond the next piece. It just helps small businesses be a lot more competitive, Mr. Chairman.
Okay. Thank you. Are there members of the committee with questions for the delegate? Are there members of the audience who'd like to weigh in on this particular bill? Welcome.
Good afternoon, Chairman and members of the committee. Deborah Bryan from the City of Virginia Beach. We thank the delegate for carrying this bill for us, and this was requested by the city, and we support it. Thank you.
Thank you. Okay. If there are no other questions, are there motions? Oh, I'm sorry, we have another witness. No?
We support the bill.
Thank you. Are there questions or motions?
Move to report.
Okay, there's a motion and a second to report the substitute for HB 1490. All in favor will indicate their preference on the voting board, and opposed do the same.
Ayes 15, no zero.
Thank you. Delegate Ware. Thank you for bearing with us.
Thank you, Mr. Chairman. I have House Bill 1418. And in short, Mr. Chairman, members, this is an effort to responsibly help meet a shortage in the field of residential appraisal. There are a number instances where people have had to wait a good while to get that. And what it does, to become a licensed or certified appraiser today requires both education hours, experience hours, and the passing of certain tests. These standards are set by the Appraisal Qualifications Board, and education is typically provided by organizations which include the Appraisal Institute, the McKissick Group, Appraisal Management Companies, and the National Association of Realtors. PARIA, which is mentioned in this bill, is a program being developed by several of these educators in the field, including the Appraisal Institute, McKissick, and several appraisal management companies, all of which have to be approved through the Appraisal Qualification Board. And the benefits of this program would be that it would put an appraiser trainee on the fast track for experience of hours through virtual training. It also would have requirements for mentors, so a trainee doesn't go through that process without a qualified supervisor. And in many respects, this program will exceed the minimum requirements currently set by the AQB. That's a short version, Mr. Chairman, but I think the gist of it is evident, what I've just said.
Thank you. So right now, if there's an appraiser, how do they get certified or qualified?
They have to meet these hours, the education hours, the experience hours, and the passing of the tests, and this essentially is allowing for experience hours in an online format.
I see. Okay. Any other questions for Delegate Ware?
Mr. Chairman?
Yes.
I have a question.
Senator
but
Donovan.
It's for Senator Bell. Is he going to compliment Delegate Ware on his dapperness?
Mr. Chairman, he looks extremely sharp and dapper today.
Okay.
Mr. Chairman.
Well, now that we've established that, Senator Mason, do you have something on topic here?
Gentleman's always Natalie clad. The mentor. Are there any requirements for the mentor? How they stick with them?
You know, I may need to phone a friend on this. I believe they have to have a certain amount of experience in the field, and I can't give you the chapter and verse on what that is.
Mr. Chairman, just, we've got such a workforce shortage in so many places, and I'm super concerned about the continual reduction of qualifications in order to get people in there.
Right.
And if you think back to the 2008 crash, what were we doing? We were saying, how much is your loan? $500,000? Your house is worth $505,000, and I don't mean to knock appraisers. They weren't cheating, but it was just the process wasn't going so well, and all of a sudden the house wasn't worth that. So I really think we need to address what you're doing. Just if we could have some parameters that mentors are actively involved, I think it'd make a lot of sense. Thank you, Mr. Chairman.
Okay. Any other comments or questions? Okay, there's a motion, a second, to report HB 1418. All in favor will indicate their preference on the voting board.
Ayes 14, no 0, 1 abstention.
Great, thank you.
Thank you, Mr. Chairman.
Okay,
Members.
before we conclude our meeting, I just want to call to the committee's attention. There's, I believe, a bill that has a revenue impact that we have to take up before next Tuesday. So stay tuned for an announcement on the floor about a meeting, either at my desk or in some other format. And with that, there's no other business before the committee, and we can adjourn.